Well, good morning. This is Dustin Hobbs of the California Mortgage Bankers Association. Welcome to a special presentation of our Legal Issues Committee. This morning, we're going to be talking about employment issues related to the ongoing COVID-19 pandemic. So we've got a lot of good information ahead, and I'm going to turn it over to Ian Rambarran, our chair, here in just a second. But I want to make sure and thank our committee sponsors, Hoge and Klinedinst. They've both done a fabulous job sponsoring this committee. And if you get any information, any useful information out of this or any of our other webinars, make sure and send a thank you message to both of those firms and keep them in mind, because they've been financially sponsoring this committee and making sure that we're able to do these webinars and provide the information that we're providing. So with that, I'll turn it over to Ian to introduce our speakers and the topic today.
Hi, good morning, everyone. I hope you're safe and healthy. My name is Ian Rambarran. I am the chair of the Legal Issues Committee for the CMBA. And as Dustin said, today we are doing a special presentation on employment issues because the world has changed. I'm currently working from my dining room table with the pool just out to the right. And as you can see from the two presenters here, we're all working from our homes. And that has triggered a whole bunch of different obligations for employers that we all need to learn about, because the laws are changing both nationally, at the state level, and even at the local level. So today we have two presenters. Our first presenter is Sarju Naran from Hoge Fenton. Sarj is the employment chair of the firm and counsels employers throughout the state. Our second presenter is Natalie Vance, who is my business partner over at Klinedinst, and she's also the managing shareholder of the Sacramento office. Natalie, too, is the chair of Northern California's employment department and does practice throughout the state as well. So with that, I'll open it up to the presenters, and I appreciate everybody being here and look forward to hearing what our presenters have to say.
Thanks, Ian. Appreciate it. All right. So are the slides back over to me now at this point? Okay, great. So thank you to Ian. Thank you to the CMBA. Thank you, Dustin. Natalie and I are pleased to present this webinar for you all today. We are in difficult and unprecedented times, and there are a lot of issues relating to employment in the workplace that are pretty unique to the challenges we're dealing with. So Natalie and I have come up with a list of topics that we're gonna talk through over the next hour with you all, and we will leave time at the end for some Q&A. So first, we're gonna talk about the Families First Coronavirus Response Act. And what is that? Hopefully you all know at this point, but we're gonna give a little briefing on that and spend a few minutes on that issue. The Paycheck Protection Program, which has been a very attractive option for a lot of companies, although it's also raised a lot of questions and challenges for folks. So we're going to focus on the loan forgiveness aspect of it in particular, since that's what pertains to employment law in particular. So then we'll talk about phasing employees back into the workplace. Everyone's now talking about what does return to work look like as we're bracing ourselves for loosened restrictions and lifting of the shelter-in-place orders. Next, we'll talk about work from home issues, and there are issues that we should all be considering as it relates to having a remote workforce, things that we typically would be thinking about and talking about in normal circumstances, but we kind of all rushed into this. So we may not have stopped to consider some of those issues, but working from home may become more of an ongoing situation, and for some, maybe more of a permanent situation. And then lastly, we're going to talk about furloughs, layoffs, and pay reductions, which are sort of the unfortunate and ugly side of things for employers, but something that's become a little bit of a necessity based on business concerns. So with that, and as I said, we'll leave questions at the end, leave time for questions at the end, I should say. I'll turn it over to my co-presenter, Natalie, to talk about the FFCRA.
Great, thank you, and welcome everyone. I'm going to just touch on this Family First Coronavirus Response Act just briefly, because in today's world, this is old news. This was effective April 1st. Employment law always moves quickly, but not nearly as quickly as it's moving these days, with statutes being passed and effective within weeks of being passed and signed into law. The Family First Coronavirus Response Act is an act that amends the FMLA to provide expanded leave protections for workers in light of COVID-19, but also provides for paid leave in certain.
Natalie, we lost the audio on you.
Sorry, we can't hear you, Natalie. All right, Sarge, do you want to jump in?
Sure. So I will jump around a little bit here, but as Natalie said, this went into effect on April 1st, 2020. So, and it's only going to be in effect through the end of the year. So it's a temporary relief for employees that are with companies that have fewer than 500 employees. So if you're a company that has fewer than 500 employees, the basic rule here, excuse me, I have to jump around here on Natalie's slides. There are two buckets of time off that employees can take advantage of, and it's paid time off, which is unprecedented. So typically time off that employees are taking is unpaid. But what Congress has done is created two buckets. One is emergency paid sick leave, and the other is an expansion of family medical leave. As it relates to paid sick leave, what the law says is that if you have a qualifying reason, you can take up to 2 weeks or 10 days of paid time off, and that you're eligible for that time off if you fall within one of the qualifying reasons. So we've got them listed here. If there's a federal, state, or local quarantine or isolation order that tells somebody that they need to stay home or care for somebody else. If the person is subject to a self-quarantine order based on their healthcare provider, if they're experiencing symptoms of COVID-19 themselves or seeking a medical diagnosis, if they're caring for somebody else who's been quarantined or diagnosed or is symptomatic, and also if employees, and this is really the big one, if because I think it's the most prevalent, is if employees need to stay home because they have a child whose school is closed or their childcare provider is unavailable, of course, due to COVID-19. There's also sort of a catch-all provision that hasn't been defined yet for conditions that might be substantially similar to COVID-19, but they're not COVID-19. And again, we haven't received guidance on what that means, so we've kind of been disregarding that. But what it essentially does is it says that if employees can't work, if they're unable to work, if they're able to work even from home, they're not going to qualify. But if they're unable to work, including from home, and they need to care for a child, or they're caring for somebody with COVID-19 or symptoms, or who's been quarantined, or they themselves is dealing with symptoms or a diagnosis of COVID-19, they can get paid sick leave during the first 10 days of time off. Now, for employees who are taking leave for their own illness, they're going to receive up to a maximum of $511 per day. So it's the regular rate of pay up to a max of $511. If they're taking time off for another person, including for a child, it's 2/3 of their regular rate of pay up to a maximum of $200 per day. So that's sort of it in a nutshell. I don't want to get too bogged down into that. Now, the next part of the FFCRA has to do with family medical leave. And many of you probably already know that FMLA only pertains to companies that have 50 or more employees. But for purposes of this law, it's companies that have fewer than 500 employees. So it's a pretty big expansion. And what it says is that in addition to the 2 weeks that employees would get under paid sick leave, they can take an additional 10 weeks under FMLA if the reason they're taking the time off is to care for a child whose school is closed or their child care provider is unavailable. And they'll get paid, again, 2/3 of their regular rate of pay up to a maximum of $200 per day for those 10 weeks. So in a nutshell, employees that are taking time off to care for a child, they can have up to 12 weeks of paid time off at $200 per day maximum. Natalie, do we have you back yet? Sorry, it doesn't sound like she can hear us. All right, well, hopefully we'll work through that. Our apologies for that technical difficulty. Okay, so next, talking about the Paycheck Protection Program. So as you may know, this is a pretty massive piece of legislation that we've already gone through 2 rounds now, and now we're hearing rumblings of there being a third round of funding. But the good news is that there's still funding available for folks out there. Initially, I think it was $250 billion initially, and now they've put in another, I think, $310 billion. But the idea behind the Paycheck Protection Program is to allow employers to continue to pay their employees. And keep in mind, this is something that's difficult for many employers to wrap their heads around, is that the point of the loan is not only to pay employees who are actually working and actually being productive. It may be to be paying employees who are sitting at home and they're unable to work or telework. So when you put it in that framework, it makes a little more sense. But essentially, what it allows employers to do is obtain a loan through the SBA for 2.5 times their average monthly payroll costs, and then they have to pay that out over an 8-week period to their employees. And the big piece of this that's really attractive for employers is that if they use the funds correctly, the entire loan will be forgiven. It ends up becoming a grant, but they're going to have to provide documentation at the end of the 8-week period in order to get the full loan forgiveness. So just to sort of talk about the criteria a little bit here, let me move on to the next slide. There we go. All right. So to maximize loan forgiveness, what employers have to do during that 8-week period. So once you get the funds, once the funds hit your account, that starts the 8-week period, and you're counting from that day to 8 weeks later. What you need to do during that time frame is a couple things. One, you need to make sure that you're maintaining the same level of full-time equivalent employees during that 8-week period as you had during a prior time period. Now, that prior time period that you're comparing it to, you can choose. Employers have the option to choose. That time frame can be February 15th to June 30th, 2019, or it can be January 1st to February 29th, 2020.
Yeah, same thing.
The one exception is if you're a seasonal employer, as determined by the administrator, which is the SBA. If you're a seasonal employer, then you need to choose February 15th to June 30th, 2019. So bottom line is you're comparing how many FTEs you have during the 8-week period that's covered by the loan and that prior time frame. And if you don't maintain the same level of employees, the loan amount that's forgiven is going to be reduced by that percentage. So if you have 40 employees in that prior time frame and only 39 now, then 1/40 of the loan is not going to be forgiven. And then as it relates to compensation levels, employers are required to maintain the same level of pay for each employee. So you're looking not in the aggregate, but at each individual employee during the 8-week period. You need to ensure that they're receiving the same pay that they received in Q1 of this year, which means January 1st to March 31st. So whatever their average weekly pay was during that time frame, you need to maintain that during this 8 weeks. Now, there is some allowance for pay reductions. You can reduce an individual's rate of pay by no more than 25% and still qualify for full loan forgiveness. If you go over that 25%, then the forgivable portion of the loan is going to be reduced by that excess amount. The one exception is if you've got an employee who makes over $100,000, you can reduce their pay by more than 25%. And while we don't have specific guidance on this, the rule of thumb that I've been advising employers is that you can also reduce their pay to a maximum of $75,000. If you go below that, I believe that portion that goes under $75,000 is not going to be forgiven. So how do you use the funds? What the PPP statute says is that you have to use at least 75% of the money that you've received on payroll costs. And for purposes of this statute, payroll includes a few different things that you might not be necessarily considering. So obviously it includes wages and salary, commissions, things of that sort. It also includes tips for employees who are tipped. It can also include medical care, health insurance premiums, as well as retirement benefits. So there's a few things that you can put into that pool in order to get that dollar amount up, but you want to ensure that you're using at least 75% of the money for that purpose. And then you can use up to a maximum of 25% of the funds to either pay your mortgage payment, lease payment, and or utility payments. So it's a pretty effective tool for those who are looking to maintain their operations, keep their employees paid. And of course, this is only for an 8-week period. So what happens thereafter is anybody's best guess. I mean, there may be some further relief that's coming. But we haven't seen that yet. But so for right now, we're only focused on this 8-week period. If you need to take further action with your employees thereafter, it's sort of business as usual. But for now, this is a pretty nice way to get your hands on some money that could effectively be free, which reduces your expenses as a business, but also puts money into the hands of your employees, which is nice.
Hey, Sarju, can you hear me now?
Yes, we got you.
Okay, great. I was going to comment too on that program. I have gotten questions from people who are concerned about what the IRS is going to consider a hardship or need for the loan in considering forgiveness, particularly in light of a lot of the news stories that have come out. There is some indication, and there has been some guidance by the IRS, that the IRS is going to be looking harder at loans that are over $2 million. So if you take a significant loan, you can expect a higher level of scrutiny as to whether there was a need for the money. But the guidance deals with economic uncertainty and not economic need. And so we're waiting to see how that is ultimately going to be interpreted in terms of whether there was a financial need for the funds or not. If you're looking at economic uncertainty, I think almost any business that is impacted by COVID-19, which is essentially every business, has a very good argument about the economic uncertainties inherent in that. So we're going to be looking to see how that all plays out coming in the future. We want to talk a little bit about bringing employees back to work.
Natalie,
there is a lot. Yes.
Natalie, can you hear me? Sorry, just one more point on that last issue, yeah, which is a really important one, because I think that's what's got a lot of employers concerned at this point. Can they keep their money? The good news is that the deadline to return the money without consequence was today, but it's been extended until next Thursday. So for the folks that are concerned about whether they actually were eligible for the funds, and whether that economic uncertainty applies to them, and it's this term necessary that hasn't been defined, but now the SBA has provided some guidance and said if you didn't need the money because you've got other sources of liquidity, you need to give it back. And if you don't give it back, there could be some pretty hefty consequences. The fine could be up to $1 million, so pretty significant. But the good news is that companies have another week to try to figure this out and determine whether they need to return the money. So the deadline is now May 14th.
Great. All right, so to talk about bringing employees back into the workplace, there's a lot of talk about it, not yet a lot of clear direction, but we are starting to see some guidance. And particularly in California, there is going to be an intersection of both federal, state, and local rules with respect to what is ultimately going to be required when you're bringing employees back into the workplace, what you're allowed to do, and what it's recommended that you do. And so we are recommending that you absolutely keep in mind guidance from federal agencies, guidance from local agencies, counties, cities, and of course the state of California. The governor recently introduced a 4-phase plan for getting the economy back to some semblance of normal. And I say some semblance of normal because I think we're all talking in terms of the new normal, as long as we're in a situation where the COVID-19 virus is still around and spreading. So we're in phase 1, which is the shelter in place right now. Phase 2 is going to involve opening up offices a little bit more in order to allow some workers to come back into the office who could not otherwise work remotely. I do still think that most workers will work remotely, but there will be some changes that allow other workers to come in and additional workforce to be in the office subject to some social distancing and other requirements. Next slide. The CDC has provided some guidance about how to considerations to keep in mind when opening the workplace and bringing employees back in. So this is definitely something that you'll want to take a look at. But employers are charged with decreasing the risks of the spread of COVID-19 within the workplace. All employers have an obligation to provide workplace for their employees. And so it's critical that you take steps to reduce the transmission of the virus in your work environment. Next. Some suggestions for doing that, of course, first and foremost, anyone that has any symptoms should stay home, and you do have the right to send them home. The EEOC, which is the Equal Opportunity Employment Commission, has issued guidance for employers about what is and is not permissible with respect to asking employees about whether they have the virus. You can ask about symptoms. You can ask about the virus. You can even take temperatures of employees to ensure that they have no symptoms. And you can send employees that do have symptoms home, because you do have an obligation to protect the other members of your workforce. Next.
One thing I'll add there is it's interesting that the EEOC has also weighed in now and said that employers can administer. Okay, sorry, I think you've got that coming up here. I don't mean to step on your next slide, but employers can actually also administer COVID-19 tests once they become available, as long as they're accurate.
That's right. And a lot of local rules are going to require you to take temperatures of both employees and customers that come into the business to ensure that no one has temperature when they're present at your facility. So normally that would be considered a medical examination, just as the COVID-19 test would be, that you would not be allowed to do. But in these circumstances, you are, provided that you protect the privacy of the individuals. So when you do take temperatures, you still have to maintain the privacy of the information that you obtain and keep it somewhere safe and locked, as you would with other confidential personnel information and as you would with any healthcare information that you have about your workers or others in the workplace. One recommendation is that you have a workplace coordinator for each facility who is responsible for COVID-19 issues and implementing them within the workplace. There also is a strong recommendation from both the EEOC and the CDC that you implement flexible sick leave and supportive policies and practices. One, you want to make sure that you don't have sick workers in the workplace, and so you want to encourage them to stay home any way that you can. And you want to be supportive of others who may have concerns about coming back to work and the risks that are inherent in being in an environment with other people during the pandemic. The EEC has noted that employers do have an obligation to engage in the interactive process if your employee requests an accommodation. And there are a number of proposed accommodations that you might consider for employees who may be at a higher risk of potential consequences if they do get the virus, or who have other concerns along those lines. And some things that you can do include increasing the social distancing between them and others in the workplace, providing protective shields between their work areas and others, finding private workspaces where they don't have to interact with other employees or customers in the workplace, or providing for remote working if that is an available option for those employees. And of course, you can always provide extended leaves of absence, and that's something that you want to consider. One thing I didn't get to cover on the legislation for paid sick leave is that one consideration is whether there are orders in place which would require an employee to stay home, or that their doctor recommends it because of a health issue. And those are, again, things to consider. So considerations: one, safety issues, making sure that you're keeping the workplace as safe as you possibly can, understanding that there's no 100% measure that you can take to ensure absolute safety. There are steps you can take. And some counties, for example, are requiring employees in the workplace to wear masks. In San Diego County, for example, starting tomorrow, all employees must wear masks, even if you're honoring social distancing requirements, if they're in the workplace. That may be something you want to institute for your workplaces. Also, having a limited number of staff in the office at any one time So you may have staggered schedules where only some of your staff comes in at any one time, encouraging remote working so that people can continue to work from home where it's safest, and other steps that you might consider. You do want to consider potential liability under the Americans with Disabilities Act and FEHA. You do want to try to accommodate individuals who have mental or physical health concerns related to COVID-19, and you want to be as liberal as possible in honoring those requirements. You do want to allow remote work wherever it's possible. In phase 2 of California's staggered plan, remote working is going to still be a huge part of it. The only workers that the governor is currently talking about allowing back in are those who couldn't otherwise work. So if you have office workers who are currently furloughed because there is not work for them remotely, those workers would likely come back. So other than just the basic operations crew, you can have a few more people, and you can have workers come in to conduct work that they can't otherwise do remotely, even if they are also working remotely, so that they can do other functions of their job on a more limited basis in the office. And it's going to be a staggered and phased approach. It's not going to be, hey, business as usual, everybody come back into the office. So you definitely want to take all of these aspects into consideration and think about how you'll phase people back in. It's not clear at what point office workers will be allowed back into the office, in mass, but probably not until the end of phase 3 or phase 4. And phase 4 is essentially back to large gatherings, concerts, sports venues, etc. At that point, I would expect there to be no limitations on working in the office. But within phase 3, I can anticipate that there will be another phased approach to bringing workers back into the office. And you'll have to just kind of take it as it comes. As you all are aware, things change day to day as we're dealing with this situation.
So Natalie, let me just touch on one of those issues as it relates to ADA liability. I think it's a really important issue, and one I think that's going to present some unique questions and challenges for employers under the current circumstances. Mm-hmm. And of course, we're in California, so we also have the Fair Employment and Housing Act, which is the equivalent, the state law equivalent of the ADA, but in some ways more expansive or more protective for employees, and that anything that limits a major life activity can be considered a disability. So, I foresee circumstances where, for instance, an employee says, I know you'd like me to come back to work, but that would create a high level of anxiety for me. And, we all tend to think of anxiety as stress, which is sort of a normal thing that everybody has to deal with. But anxiety is a medical condition, at least potentially. So, when you're hearing words like that from an employee that, I would be too anxious, or it would give me anxiety to return to work. And of course, they don't have to use the buzzwords. They just have to be expressing these sorts of things. If they're conveying something that's potentially a medical issue or a disability, that's something that you're going to have to consider as part of that interactive process. And you may not otherwise be thinking, oh, we need to engage in a potential discussion about a reasonable accommodation right now. But that might be a trigger that on its own. And then you've got, of course, folks who,
absolutely.
Yeah. So, and then of course, you've got folks who do have medical conditions that go beyond anxiety, and they think, okay, well, I'm part of the vulnerable population. Well, and some employers who are already looking at reopening their workforce, they're thinking, we're going to tell our employees that you're not allowed to return if you're over the age of 60 or if you have a medical condition. Well, we don't get to play doctor, right? And while these are the guidelines that have been issued by the CDC and other agencies, and it's a good rule of thumb, we don't get to impose those sorts of restrictions. So, it can potentially create a risk, because if you've got folks that are vulnerable that are coming into the office, it's not good for them. But we don't necessarily get to say that to them unless you can see that they're creating a safety risk to themselves or others. So those folks, I think my recommendation is you don't prohibit them from coming in, but you advise them that generally in a non-targeted way that if you have a medical condition or you are part of a vulnerable population for any of a number of reasons, consider whether it's appropriate for you to return. And then, of course, if those folks don't want to return, you can certainly ask for a doctor's note. But as Natalie said, I think that we're going to want to be pretty flexible in terms of accommodating folks in their ability to continue to work remotely, or not work at all if they're not able to do so safely.
Absolutely.
Next one.
So
Okay.
I put a few websites that you can take a look at. These are some EEOC frequently asked questions dealing with the intersection of COVID-19 issues and the ADA and bringing workers back. So I recommend you take a look at that in addition to the resources on the CDC website, and of course your local, state, and other federal agencies have information about this that you should be looking at regularly. One of the things we're finding too is that things are changing day to day, even with the shelter-in-place orders and the phased approach to opening and closing different areas of your business. Although there may be an order that comes out that says it's effective through the end of May, there will be additional guidance or new orders that come out that may shorten it, lengthen it, or add new restrictions or release other restrictions and provide, more freedoms than what currently were there. So it's almost something that you should be doing on a daily basis, and if not daily, at least a couple of times a week, updating to see what requirements are governing your offices and your businesses. Great. Next.
Okay, so issues working working from home. As I noted earlier, I mean, we were all sort of forced into this situation pretty quickly and without very much notice. And some of us were better prepared than others, in part because many employers already have employees that work from home, and they know what that looks like and what it should look like. For many others, and I'll say for my law firm as one example, we have, I think, 2 employees that work full-time remotely, but those are very much one-off circumstances, and it's not the norm, especially for our non-attorneys, right? So they raise interesting issues and challenges, and so just wanted to talk through a couple of those here. Under ideal circumstances, when we're advising companies on how to manage employees that are working remotely, we're going to want employees to sign a work from home agreement. And one of the big things in that work from home agreement, while we're trying to cover the gamut of issues that could arise from working in a remote environment, one of the things that we want to consider is this work from home arrangement for the benefit of the employer, or is it for the benefit of the employee? Because that could have a pretty significant impact in terms of what expenses the company needs to pay for. So right now, we have not yet seen this, but I know it's coming. It's an issue that's got to be percolating. And I know, some companies are thinking, wow, we're able to save a lot of money by having people working from home. Of course, you've got your office space right now, but under ideal circumstances, maybe you can downsize. We can have a smaller footprint and have people working remotely. Well, it's a great idea, but keep in mind that the law doesn't allow you to simply pass your operating costs off onto your employees. There was an important case on this a few years ago related to cell phone use, and it was a situation where an employee was using their personal cell phone with an unlimited data plan, unlimited texting, unlimited everything. They're paying one fee for the entire month, but they were using their personal phone for business purposes also. And then the employee sought reimbursement, and the court basically said, even though it's not costing the employee any additional money to use their personal phone for business purposes, the company is passing its operating costs onto its employee by requiring its employee to use its personal phone for business purposes. So for that reason, the company is going to have to pay at least a portion of that cell phone fee, right? The monthly expense. And extrapolating from that logic would suggest that there's a whole bunch of expenses that an employer may need to reimburse the employee for when they're working from home. And I've heard these claims in the past, not as often as I would expect, and I think they're going to continue to come. But what the law says, Labor Code Section 2802 says that an employer needs to pay for all necessary expenses that are incurred by an employee in carrying out their duties. And necessary expenses are considered those that are reasonable, and ones that are appropriate in performing the work that they do for their employer. If you've got employees working from home, you're asking them to dedicate a space in their home for work purposes. That doesn't mean that it can't be used for personal use as well. I mean, I'm sitting in my bedroom right now. I sleep in this bedroom, but I'm also working in this bedroom. Should my employer be paying a portion of my home expenses? You know, my electricity, my water, my toilet paper, things of that variety, right? Utilities, a space in my home, because company currently isn't providing an option for me to work in the office, and it's not because the company doesn't want to, it's because the law doesn't allow it to. So as a result, there's a number of things that an employee could potentially be seeking reimbursement for that could be problematic in that, you know, companies aren't currently considering it, and it would increase their operating costs, especially right now, because you're paying for your office that's vacant as well as for people's home office expenses. So sort of as a general rule of thumb, what I advise employers is that if you're going to have employees working from home under non-pandemic circumstances, think through, is it the employee's choice or yours? Because if it's for the employee's choice and you actually give them the option to work in the office and you have facilities and equipment available for them, well, then you don't have to pay for them to work from home, because that's something that they want to do. You're not requiring it. You're giving them all the tools and facilities they need to be able to work effectively in the office. But if it is for the employer's benefit, as it is right now, because without employees' ability to work from home, they're simply not working, which is detrimental to the company. Consider at least providing a few things. You don't have to go all out and say, we're gonna pay for your increased utilities, provide us copies of your expense bills, all that sort of stuff. But provide at least what I call an office in a box. You know, a cell phone, a computer, a printer if necessary, keyboard, mouse, all the peripherals that an employee would need. You should pay for a portion of the internet coverage, which may mean that you're also paying for the modem and router. But those are things that an employee needs to be able to work from home, because if they don't have that, they can't do their work. Obviously, that depends on the office environment, but in this particular industry with mortgages, with mortgage banking, you're going to need that technology available to you. Before I move on to the next issue here, Natalie, did you want to chime in on the expense issue? Uh-oh, we've lost you again. Oh no. All right, we'll work on getting you back. I'll continue to keep going. All right, so that's all I'll say about that for right now, and of course we'll take questions on that at the end if hopefully we have time for it. The other issue that employers need to consider with employees working from home is wage and hour compliance, which, you know, as an employment law practitioner, I see many more cases of wage and hour allegations and violations of wage and hour, allegations of wage and hour violations than any other claim. And that's typically because there's a ton of gotchas in the law. The statutes are not built for the protection of employers. They're hard, they're complicated, and there's a lot of attorneys out there that are seizing on the opportunity to bring a claim based on wage and hour violations. It's already tough enough when you're in your office environment to ensure that your employees are taking their rest breaks and their meal breaks on time, and that, you know, they're taking their meal break before the end of the 5th hour, and that they're taking it for at least 30 minutes, and that they're relieved of all of their duties and they're allowed to leave the premises. Right? It's hard enough to do that when you're on site, but when you add to that the fact that these folks are not under anyone's oversight, you know, it's kind of out of sight, out of mind. You're thinking about them, you're hoping they're doing the right thing, but of course, particularly given the situation that we're in right now, where employees are juggling their work responsibilities as well as their home responsibilities, they might have children in the next room over that need to be tended to at some point throughout the day, which means that employees are really looking for flexibility in their schedule, which of course employers may want to provide that flexibility, but how do employees then track the time that they're working, and are they doing so accurately? And if they're not, that could create exposure. That could create exposure for off-the-clock work. So employees claiming, I worked overtime, but I didn't document it. Well, why didn't you document it? That's always a good question, right? But meal and rest breaks, did you take your rest break on time? Did you take your meal break on time? So it's important that employers are vigilant during this time frame to make sure that their employees are accurately filling out their timesheets. If what you're seeing at the end of each time period, each payroll period, is a bunch of 8 a.m. to 5 p.m. and lunch 12 to 12:30, and it looks exactly the same on every day, that should raise suspicions. That doesn't look very accurate. And you want to make sure that employees are being accurate and truthful in terms of what they're writing down as their hours. So this isn't necessarily new guidance, but it's put into a different context with folks working from home. Natalie, do we have you back?
I think so. Can you hear me now?
Excellent. Yes, I can hear you. Anything on those two issues before I move on?
Great. Now, you made my comment on the reimbursable expenses was, where are you getting your toilet paper that you're getting reimbursed for? Because I think we all want that hookup. But I think I agree with you. If you're providing the office equipment and the portion that would be allocated towards work hours, you should be okay. But of course, creative plaintiff lawyers could try to expand that in the future. So it is an area to be careful of. And with the wage and hour compliance, if you don't have an electronic system for your hourly workers to log in and out remotely, one thing that we've been doing at our office is just having our hourly workers email when they start their day, when they go on their break, when they return from their break, and at the end of the day, email that they're logging off. So that we do have that record of their time.
Right, and have them sign certifications certifying that the information they've provided is accurate and that they haven't missed any breaks. And if so, if they have, then they need to talk to their supervisor about it. Okay, as it relates to workers' compensation insurance, just keep in mind that workers' comp still does apply if one of your employees injures themselves at home. So I won't say a whole lot about that, but under better circumstances, you would have an agreement that even provides that you have the ability to come in and take a look at their workspace and their home environment to ensure that it's safe and hazard-free. You don't have that opportunity right now. So all you can do is really remind your employees to please be safe. But there may be an open question if somebody were to get injured at home. Were they working when it happened? Was it related to work or was it not? So just something to have on your radar, but we won't say much more about that at this point. Okay, and then our last topic before we move on to questions, terminations, separations, and furloughs, which are unfortunate but somewhat necessary for a lot of employers. We've already seen, I've seen at least one round already. For some employers, I've already seen 2 rounds. But companies are considering, what do we do during these circumstances? Our operations have come to a halt or they've been significantly slowed down. You might be a small business owner that really can't handle financially the impact of the shutdown. So with that being the case, a lot of companies are looking at their options, right? You can reduce pay, you can reduce hours, you can put people on furlough. And a lot of folks, they are putting their employees on furlough and saying, we're going to maintain your health benefits, but we can't continue to pay you. And the good news is that in a situation like that, if you're putting them on furlough, even though you're paying for their health benefits, they are eligible for unemployment. And unemployment insurance benefits right now, as I'm sure you may know, are a lot more generous than they have been, right? So typically the weekly benefit in California maxes out at $450 per week. But now with the CARES Act, there's an additional $600 on top of that $450. So an employee can make up to $1,050 per week being unemployed. If you've got folks that have reduced hours, so they're working, but they're not working full time, you've taken them from 5 days a week to 4 days, for instance, they may be eligible for partial unemployment benefits. So they can make up some of that loss through UI, which is excellent. But of course, in some circumstances, reduced pay and furlough isn't sufficient. It's not going far enough, and you may need to lay people off. So one thing to keep in mind, there's a few things obviously, but one of the things that you need to keep in mind, if it's a group layoff of more than 50 employees, and you've got more than 75 employees total, that would be a trigger for warrant under California law. Under federal law, the requirements are a little bit different. So for larger employers, if you've got more than 100 employees, and if you're letting go of more than 50 employees, and that represents more than 1/3 of your workforce, or if you're letting go of 500 employees, you've got obligations under warrant. Importantly, 2 things. One, a furlough is treated the same as a termination for purposes of warrant. It's a separation from an employee's position, not necessarily from their employment. You're not terminating their employment, but you are separating them from their position. So that would be a trigger under warrant. And what that means is that there's going to be a bunch of notices that you're going to have to need to send out. The general law under WARN is that you've got to provide 60 days notice, at least 60 days notice, to the employees and to several governmental agencies. If you're a unionized workforce, then also to the union. The good news is that Governor Newsom did issue an executive order given the pandemic, and said that given the current circumstances, we're going to relieve employers of the obligation to provide 60 days notice, as long as employers are providing as much notice as practicable. So for many employers, it's not very much notice. I've seen in some instances, it's only 2 days notice. We're saying, hey, we need to make a bunch of cuts. We need to do it now. Let's figure out who's going to be on that list, and then they can notify them. But their obligation is still to provide that WARN notice, and there's certain requirements under the WARN Act for what needs to go into that notice. And then you're also providing that same notice to a bunch of governmental agencies. So keep in mind, whether you're doing a mass layoff or a mass furlough, that might be triggered if you have sufficient numbers. Let's see here. The other couple issues with respect to mass layoffs is that if you're going to be laying off more than one person, and you're providing a severance agreement and asking for a release of claims, in order to get a valid waiver of an age discrimination claim from employees, you're going to have to satisfy the requirements under the Age Discrimination and Employment Act, which means that for employees that are 40 years old or older, typically, if you're going to give them a severance agreement, you have to give them 21 days to consider that agreement. And then even after they sign, you have to give them 7 days to be able to revoke that acceptance before the agreement is valid and before that age discrimination claim is valid. But with a group layoff, that consideration period goes from being 21 days to 45 days. That's an important piece of this. So any employee that's 40 or over needs to be given a month and a half to review that agreement before they can be required to sign it. And then second, you're going to have to provide them with an informational chart that identifies, not by name, you don't have to identify who all the employees are, but whatever your decisional unit is if it's the entire company, then you need to identify the titles of every employee in your company and all of their ages, and then provide information on whether each person is being laid off or not. And that allows those that are being laid off to determine, by looking at that chart, does it look like this company is simply letting people go because they're over 40? If it's not, if the decisional unit is smaller than the whole company, it may be that you're only looking to cut people in a certain department. And if that's the case, you only need to provide an informational chart for that department. So if you're only cutting people within a department of, say, 10, and you're letting go of 5 people, you only need to identify the titles and the ages for those 10 people and identify which of those are being let go. So those are technical requirements, but something that could get lost in the fray when we're thinking about everything else in a situation like this. Natalie, you want to take on final pay obligations?
So with the final pay obligations, you need to be aware that, whenever you let someone go, you have an obligation to ensure that they have been paid everything that they're owed in terms of all wages and any vacation or PTO that they may have accrued up to that point. And that has to be paid on the day of termination, or you'll be subject to waiting time penalties for each day that the employee has to wait for that final pay. So a furlough, if there is no designated date to come back to work, actually qualifies as a termination for purposes of final pay. So you do need to be aware that it's not just termination of employment, but when you furlough a worker for an indefinite period of time, then you also have that final pay obligation on the date of the notice. One thing too that I'd like to add here is that when you're considering furloughs and layoffs, it's better. Be proactive in planning ahead. If you wait until you have no money to pay workers, you can be in a situation where you have employees who are owed wages that you can't afford to pay. And in that situation, you're going to be looking at many wage and hour violations, penalties, and issues that can arise from that. And along with the Age Discrimination and Employment Act, you want to make sure that the employees who are targeted for furloughs and layoffs have some legitimate business necessity behind it, and that you're taking steps to ensure selecting a particular employee. So you want to tread with caution as you would with any termination from employment.
So it was a little bit hard to hear a portion of that, Natalie, so I'm going to backtrack just a little bit. I heard most of it, but as it relates to the final pay, I just wanted to sort of echo to make sure that people understood what Natalie was saying. A furlough, even though it's not a termination of employment, could trigger a final pay obligation. If there's no definite date for them to return that's within the same pay period as they've been furloughed. So if you're talking about a 2-day furlough or a 1-week furlough, that's one thing. But if we're talking about a furlough that's going to last more than the current pay period, and there are two opinions, and it's frustrating because these are coming from the Department of Labor. The most recent guidance on this is from 1996, and the prior guidance from that is from 1993, so it's pretty old. But arguably, that furlough is going to trigger a final pay obligation, which would then require you to pay out that employee's PTO when you put them on furlough, which may sort of defeat the point, because the reason you're putting them on furlough is because you're trying to save on labor costs, but you might end up having to take all that debt off your books, which it's a good thing to take that debt off your books, but you might not have the financial ability to do that. And if you don't, that's a problem, right? You may need a second to question whether you actually can furlough that employee or not. All right, so with that, we're done with our prepared comments, and we want to open it up to you all for questions. So Dustin, have you taken over the slides?
Yeah, thank you. Thank you both. Great presentation, a lot of good information in there. So if you have any questions for either Natalie or Sarju, you can use the questions module there, and we'll answer them as we go. And as folks are putting in their questions there, I will mention that the webinar is being recorded and will be available. The recording will be available on both our YouTube channel, and it will be also available on the California MBA's website, likely either later today or tomorrow morning. So we got a couple of questions here right away, and I'll jump in and read them here. And Natalie or Sarju, whichever one of you wants to handle this, jump right in. So the question is, if the employee files for EDD and normally works full-time, but has been working reduced work hours during COVID-19, is there an amount of income that they make weekly it will disqualify their EDD claim during the weeks they make a disqualifying amount of income? What is that amount? And thank you.
So I actually don't know the answer to that question, other than, I mean, I can tell you that there is a weekly maximum. There is criteria. I don't know what those amounts are, to be honest with you. We always focus on this from the employer standpoint as opposed to what employees are eligible for. The EDD is a good resource for that. You can determine what benefits you're eligible for through the EDD's website, and they have a weekly benefit calculator. But I do believe that if you make over a certain amount, you may not be eligible. And of course, the amount that you are eligible for, if you are eligible, is going to be based on how much income you make, and that could fluctuate from week to week. What I have found during this pandemic is that the EDD is being a lot less discerning and basically handing out money like it's candy, which is great for our employees, but unfortunately, it's also creating a problem for employers in that some employees would rather not work because they make more money not working than if they're actually performing their duties. But the good news is for employers, if an employee refuses to work and there's work available for them, they're not eligible for unemployment benefits. Of course, they may still receive it anyway, but again, that's not your responsibility as an employer. You can notify the EDD that your account should not be impacted by that unemployment claim because you offered the work. But that's more of a logistical question and timing issue.
Great, thanks. Oh, go ahead, Natalie.
Employees who have had to apply to the EDD for unemployment, whether or not they think they may be qualified, there's no harm in them submitting the application, and they are getting paid unemployment benefits. They're far less likely to come back at you in the future for reducing their hours.
Got it. Thanks, Natalie. So next question here. The question is that they're saying that they know that someone has a coronavirus at their company. And the question is, am I allowed to communicate this to others, or how? I guess maybe the question is, how and when and who are they allowed to communicate that to?
Right. Natalie, you want to take this one?
Sure. So you absolutely are permitted to communicate the fact that someone in the workplace tested positive and what remedial steps you're taking. You should not communicate the identity of the individual. You have an obligation to protect their medical privacy. So while you do have an obligation, particularly to notify workers who may have come in contact with the individual, that they should be tested and that they should probably stay home until they're tested and verified that they did not also contract it. You want to notify everyone that it's happened. The recommendation is that you have the entire office area where the individual was disinfected, and that you notify individuals that were within close contact or would have had contact with the person or anybody that would be coming into the suite. You don't have to notify all of your employees of the issue. But again, this case-by-case basis, as long as you're protecting the privacy of the employee, you are free to notify others so that they can make decisions about their own health.
Right.
So
and
now,
I think under OSHA, the recommendation is that you do provide that disclosure. So again, you can't identify who the individual person is, but as part of your obligation to maintain a safe and hazard-free workplace, you should notify those that have been exposed. It may be difficult to identify specifically who has been exposed. You can ask the employee, who have you been in contact with for the last 14 days? But I think a lot of employees might be hard pressed to give you a finite list, which is why I think a broader disclosure is appropriate. Unfortunately, that doesn't necessarily tell people how concerned they should be, but it does alert them to the fact that somebody in the company has been diagnosed as positive, so they should be self-monitoring and potentially consider seeking care.
Great, thanks. And so real quick, I'll throw in here, since we're getting real close up to noon here, we've got a ton of really good questions here, and we're obviously not going to have a chance to get to all of them. But I will let if you've asked a question and we didn't get to it, just be sure to know that I'm going to make sure that all the speakers get the questions and they'll be able to answer your questions offline. So as sort of a follow-up to that last question, what if the person works totally remote and has been for a while? Then what are your obligations as far as communicating that to, if they've tested positive, communicating that to any other staff or administration?
If they haven't been in contact with anybody for the last 14 days, then you don't have an obligation to disclose.
Okay.
So if you have someone who is working remotely, for example, and has had no physical contact with anyone else, you don't have any obligation to disclose to any other employees. You'd just be working with that employee to perhaps provide them with a paid sick leave benefit and things along those lines. And of course, to make sure they don't come into the workplace until at least 14 days after the system.
Yep.
Got it. So, so we'll go last question here, and then we'll close out here. If the employee volunteers to be furloughed, is the last pay payable immediately?
I'm sorry, can you repeat that, Dustin?
Sure. It says if the employee volunteers to be furloughed, is the last pay payable immediately?
So if there's a voluntary separation, the pay is due 2 days after?
72 hours.
3 days after. You get a grace period, but you still would have the obligation to pay the accrued PTO. You just have a little more time to do so.
Got it. All right, well, I'll turn it over to Ian here in a second, but I just want to remind everyone again that thank you for your good questions. I'm going to send those on to the speakers, and they'll be able to respond to you offline. We've also got another webinar next week on May 14th, where we're going to be covering a lot of issues, again, around COVID-19. We're going to be specifically diving real deep into the CARES Act. So as you can see on your screen there, we're going to have a lot of good speakers and cover a lot of ground on the CARES Act. So Ian, do you want to jump in and close this out?
Yep. Thank you, Dustin. Thank you, Sarge and Natalie. We really appreciate it. It was a great presentation all the way from the dining room table to what the office of the future looks like. So I think it's applicable to everything that we do and everything that every employer is going to have to do in the future. So thank you very much for being here to do that. We appreciate it.
Absolutely. Thank you.
All right, and that concludes this morning's webinar, and we will again see you next week on May 14th for our Legal Issues Committee's regular quarterly webinar. Thank you for joining us.
Thanks. Bye.